How are you going to pass that real estate exam? Well, you're going to pass it by learning lots and lots of questions, practicing them, and the vocabulary that's in the questions, right? And I point them out during this class, okay? And I explain the questions and then the answers and point out vocabulary in the answers so that you realize how much of a new language you are learning, and you need to learn the vocabulary. So let's get with it. This is Wild Lily Handy coming to you from San Antonio, Texas with YouTube AgentPrep. Let's get with it. So I'm going to share my screen and continue where we left off. And let's see here. And participate during the class. Okay, this is for, okay, where am I here? Okay, I don't want to do that yet. Wow, let's see, window. Okay, I'm getting with it, all right. I'm getting with it. Okay, so we're starting with question 411. And the topic of this is agency and listing agreements. This applies to all 50 states. And the book that we're using is this one here, Texas Real Estate License Exam Prep. This is in 26 states. However, you buy the book, it gives you all the national questions and the answers, explain, reviews the what the exam is about, what real estate about, all the different topics that you studied and all the courses that you took before you took the exam. And it is by the Metling father and son and Cusick and Hamilton authors, and I have permission to use the book. Great family. Okay, so hi, Lisbeth, good morning. Hide this, hide that, enlarge this. And type the question number and the letter answer, please, so that we all know that we're on the same question. Sometimes there's a delay, and someone that types an answer might be from a prior question. So it's important so that I can help understand where you're at and how I need to, if for some reason, an answer was incorrect. All right, here we go. Okay, who's my Facebook user here? I've got a Facebook user. Okay, those of you that are on Facebook, go to StreamYard.com/Facebook and give, hi, Esme. Okay, so yeah, oh, Esmeralda. Hey, all right, so look at this. Esmeralda is in Texas, and she passed her exam on the first time. She let me know yesterday. And isn't that awesome? So Esme, okay, would you, oh, my niece is also Esme. And when people would say, what's your name? They said, Esme. Well, I already asked you, what's your name? Esme. No. What is your name? I'm telling you, my name is Esme, Esemi. So I'm so grateful for your comment. Okay, Esme, that you passed. So share with us what you did to pass. And if you can go to StreamYard.com, I typed it on Facebook, click on that link, and then let Facebook show us your name like this, okay? And like this. And that way everybody knows. Otherwise, it shows just Facebook user. But so much congratulations to you for passing that exam and letting me know. I believe you're in Houston, right? If you are, hey, write some comments, encourage everyone else, and, give them an idea of what you did and what you did while you were there and before you went to the exam to get you relaxed. All right, number 11, the duties of a transaction broker or a facilitator include what? A, preserving the confidentiality of information received from either party. B, helping the two parties achieve their respective objectives. C, disclosing material facts that affect the value of the property to both parties. D, choosing to obey the instructions of one party and informing the other party of the decision. So what are the duties of a transaction broker? What does it say? Transaction broker or facilitator. Type your answer in the chat. So far, we've got 11C. And the answer is 11C. Disclosing material facts that affect the value of the property to both parties. So the role of the facilitator, okay, the broker's only fiduciary duties and standards of conduct, or those of accounting skill, care, and diligence, honesty, and fair dealing, and disclosure to both parties of all material facts and residential sale transactions affecting the property's value. Some states do not allow for this form of relationship in a real estate transaction. So it is the transaction broker or a facilitator disclosing material facts that affect the value of the property to both parties. And also some transaction brokers are brokers that don't provide a lot of training, and they charge you a small fee per transaction. And it's more for experienced realtors that are not really doing a lot of transactions. Hi, Paige. Thanks for joining us. So they facilitate the transactions, okay, but don't charge a lot of commission. Again, that is for experienced realtors. Let's see, how do I hop on via YouTube AgentPrep? Okay, let me give you that link. Okay, try that link that I just posted on Facebook and see if it takes you here. It should. So where can you put a complaint if someone is working as an agent and broker at the same time? Oh, they can do that. A broker can be an agent. They just, if they're going to have both parties, represented, then they've got to have two different realtors. But a broker can also be an agent, a realtor. There are individuals that have a broker license and they practice real estate, and it might just be them. They might have an office as a brokerage and it's only them. I did that in Oregon. I was the broker, the principal broker. That's what we were called in Oregon. And then a realtor was called a broker, right? So it depends on one state. However, brokers can also do real estate. In fact, absolutely. The only time that they cannot represent, or advise and direct and negotiate is when they're an intermediary in Texas. Okay, if they're a dual agent in some other state, they can represent both. If they're only representing one party, then they're acting like an agent in addition to being the broker or a broker. Okay, they can be a broker and not be the designated broker of a brokerage. Okay, so good question. Great question. All right, number 12. Now, if it was a realtor or an individual doing real estate without a license, then that could be a complaint to Texas Real Estate Commission. Okay, because that's illegal. But be careful that they're not a wholesaler and they're in the middle of a transaction. They write a contract, they put it under, hold and then they assign it to somebody else. So hi, Bailey. Okay, number 12. So did I show the answer for 11C? Yeah. In which of the following contact situations would a seller's agent be expected to disclose their agency relationship? Okay, in which of the following contact situations would a seller's agent, so an agent that's representing the seller, be it a broker, and of course it's going to also be the broker, right? Because all transactions belong to the broker. But there's an agent in specific that is dealing directly with the client. So they're representing the seller. A, the agent is showing the client's property to a prospective buyer. B, the agent tells an acquaintance that at a party about the client's property. C, the agent answers questions about the client's property for a telephone caller responding to a newspaper ad. Or D, the agent is showing a potential buyer houses in a certain price range in multiple listing books. So in which one, and you're going to say multiple listing book? Yes, that's what I used to use in Oregon back in the 2000s. So in which contact situation does the seller agent must disclose their agency relationship? Great. Yes, excellent question. All right. So Esmeralda, were you able to get onto the live? All right. So type your answer in the chat. There's quite a few on you here. Don't be shy. Take a risk. A, apple, apple, and the answer is A, apple. The agent is showing the client's property, the client that they're representing, the house that they're representing, to a prospective buyer. So let's say you're at an open house for your listing, representing the seller. So buyers come in, they could become your client, but not on that property. You could write the contract for them, but not represent them. Therefore, we must disclose, hey, I am the seller's agent for this particular property. So A, everyone answered A? Yes, awesome. Number 13. I might go a little faster today, okay? The essential foundation of the agency relationship consists of what? A, mutual respect, compensation, and confidentiality. B, diligence, results, and compensation. C, service, marketing, and respect. D, good faith, trust, and confidence. Essential foundation of agency relationship. Type your answer in the chat. Oops, I forgot to put my phone on mute. No, it is not A. Remember, compensation is not a requirement in an agency relationship. Respect and confidentiality are. So A and B would not work because you've got compensation in there. So the foundation of agency relationship, we have good faith, okay, when working with them, trust and confidence. Yeah, so the answer is D. Hey, Esmeralda. Look at that. She joined us on YouTube. Awesome. Thank you for joining on YouTube. It helps my analytics, right? The more people watch my video, the more YouTube promotes it, or advertisers want to advertise, because I'm already earning money from YouTube, right? It took me, a couple years or more. Actually, less than that. I started this channel in November of 2020. Yeah, and by September of 2022, I started making money with YouTube. It's only at like, $50, $70 a month right now. But hey, eventually it'll grow. So that's another way to earn money, is having a YouTube channel. It does take a lot of work. It can be fun and enjoyable. All right, number 14. Audrey wants to take a vacation. To do so, she authorizes an agent to conduct the operations of one of her business enterprises. The kind of agency she has established is what? A, limited, B, general, C, universal, or D, special. So what does it say? She's going on a vacation. She authorizes the nation to conduct the operations of one of her what? Business enterprises. What kind of agency does she have established? Paxton, hey, dude, or dudette. Hey, money grows, yes. When they'd say money doesn't grow on trees, well, the trees grow fruit or vegetables, and then you sell it. So it does grow money. All right, the answer to number 14. All right, number 15. A property seller empowers an agent to market and sell the property on their behalf. The kind of agency represented is A, general, B, special, C, universal, or D, no agency. Yeah, right? Vegetables and trees generate money when they produce fruit for farmers. So it empowers a property seller, okay, one property seller. It empowers an agent to market and sell a property, one property on their behalf. So what type of relationship, agency relationship is that? You have many versus one. Come on, type your answer in the chat. If not, we're moving on. Hi, Anai. Thanks for joining us. The answer is B. All right. Very good, right? Because it's one specific property. When it is one specific property, we are a spatial agent. We're special. Right, number 16. When we are overseeing many, we're a general, right? We are general. (16) Implied agency arises when what? What is implied? What is agency? Okay, I forgot to point out vocabulary words. A, an agent accepts an oral listing. B, a principal, who's the principal, accepts an oral listing. What kind of listing? Oral listing. C, a party creates an agency relationship outside of an express agreement. Or D, a principal agrees to all terms of a written listing agreement, whether express or implied. So what is an implied agency? When you imply something. Yes, special. Well, thanks for joining us, Esmeralda. But I understood correct, right? That you passed both the national and the Texas state. It is not D. Because D says a principal agrees to all terms of a written agreement. Okay. You don't have to have an agreement. It doesn't even have to be verbal. It has to be, we're working with that individual. Okay. So the answer is actually C. A party creates an agency relationship outside of an express agreement. So it is implied. The client is going out with us. Okay, they may not be a client yet, they haven't signed anything, they're a buyer, a prospect, right? And they continue to go out with us to show properties, view properties, and we let them know, hey, we're going to go look at these properties and that type of thing. So it is a party creates an agency relationships outside of an express agreement. So in more detail, an agency relationship can arise by implication, intentionally or unintentionally. Implications mean that the parties act as if there was an agreement, right? For example, if an agent promises a buyer to do everything possible to find a property at the lowest possible price, and the buyer accepts the proposition, there may be an implied agency relationship, even though there is no specific agreement. Got it? So D says they have all terms of a written listing agreement. No, they don't have to have all terms of a written listing agreement. A, an agent accepts an oral listing. No, what if it's a buyer? Okay, so they just say an implied agency relationship arises. So it could be a seller, it could be a buyer. So it's a party, a principal. Okay, an agency arises when a party creates an agency relationship. You have an implied relationship. So a seller says, yes, I'm going to list it with you, or I like what you're doing. You know, I've been following you and I want to sell my home, you know, and I want you to do this and do that. That's implied that they're going to hire you, but you want to get it in writing. So A would not be an example, right? Yeah, it would not. Why? Because it's an oral listing. Okay. So we're not accepting anything orally. We're just implying that we're doing something together. So look up the word imply, okay? Vocabulary. Implied agency relationship. Number 17. So that makes sense, right, Paige? Good. Glad you got it. An agency relationship may be involuntarily terminated for which of the following reasons? So an agency relationship, right, there's already something signed, may be involuntarily, okay, they didn't volunteer to terminate it, for which of the following reasons? A, condemnation of the property. B, mutual consent. C, full performance. Or D, renewal of the agent's license. So how could it be terminated without either party wanting to terminate it? It's involuntarily. The client didn't volunteer to terminate it. The realtor brokerage didn't volunteer. The agent didn't volunteer to terminate it. So there's only one possibility in this question. So what is condemnation? What is mutual consent? Full performance, renewal of agent's license. 3 of those, okay, are incorrect and 1 is correct, which is typical, right? So we've got A. Yes, the answer is A. Condemnation of the property, right? So what is condemnation? So it is one of the government powers to take over land for public use, and that is the act of taking over the property. Okay, so once they inform that they want to take over the property to widen the road or create some other things for the community, then they do a condemnation. So the government has a right to condemn the property, the act, so the right to condemn and the act to condemn. Okay, so once it's condemned, that means it's got to go to court and the judge is going to approve the condemnation. The taking over the property with a current market value financial compensation. Number 18. Okay. Jeez. Okay, there we go. 18. A principal discloses that she would sell a property for $500,000, $500,000. During the listing period, the house is listed and marketed for $530,000. No offers come in and the listing expires. 3 weeks later, the agent confides to a customer that the sale would have sold for less than the listed price. Which of the following is true? A, the agent has violated the duty of confidentiality. B, the agent has fulfilled all fiduciary duties since the listing has expired. C, the agent is violating the duties owed to their customer. Or D, the agent has created a dual agency situation with the customer. All right, so what did it say? The property expired 3 weeks later. Okay, the seller wanted 500, it was listed it for 530. 3 weeks later, and it expires, whatever period it had, maybe 6 months, 3 months, whatever it was, and the agent confides. So what is one of our requirements, our fiduciary? What is the one thing that remains after a contract and an agency relationship terminates? No, it is not. It is not B, Paige. Take another attempt. When you have an accountant, you have an attorney, you have a doctor, you have a specialist, and a counselor, what do they have to keep between client and themselves? No matter whether the relationship ends or continues. That is correct. Confidentiality, right? The agent has violated the duty of confidentiality. Confidentiality remains forever. Disclosing the price that the seller would have taken is violating confidentiality, because another realtor might end up listing it and they may have told another realtor, right? Or a buyer that might go and buy it. So that's correct. Confidentiality. That remains, okay, with all types of professionals. Well, certain types of professionals, okay. So 19, a principal instructs an agent to market a property only to families on the west side of the university campus. The agent refuses to comply. In this case, A, the agent has violated fiduciary duty. B, the agent has not violated fiduciary duty. C, the agent is liable for breaching the listing terms. Or D, the agent should obey the instruction to salvage the listing. Okay, so the principal is instructing an agent to market a property only to families on the west side of the university campus. Agent refuses to comply. So if it's looking blurry, okay, Lisbeth, it must be at your end, the resolution. because on the screen, it looks clear. So on the bottom right of your YouTube, you'll see a little gear. Click that gear, okay, and improve the resolution to 720 or 1080. Can I make the font larger? Yeah, that's what I do when I change this. But sometimes if I go too large and it doesn't show on one page. So there we go. Yeah, it depends if the question is large or small. Oh, thank you for mentioning that. Oh, if you're on your phone, it's going to look small. That's why I keep changing it, trying to accommodate for those that are watching on their phone. Oh, wait a minute. We were on number 19. Oh my gosh, sorry. Right? Yes, we're on 19. Dang it. There we go. Excuse me. You're on your laptop. Okay. So I'm on my laptop, and my laptop is narrow because it's a Microsoft Surface Pro. So maybe change the resolution on your screen or enlarge your YouTube screen since you're watching on YouTube page. Click it to on the lower right-hand side of your YouTube video. The last little box on the right will make it full screen, will enlarge it to cover your whole computer screen. So let's see. Can you adjust like you did before? Okay, I think that's going to be the biggest that I can do this one. Okay. Wait. Okay, that's going to be the largest. I think I can get it. It looks better on Facebook. Oh, okay. Thank you for that. Mine too. Same laptop. Oh, okay. All right. So hopefully that looks a little bit larger. Because if I go larger, and I have the boldest font too. Okay, there it's larger. So we're on 19, right? Yes, I had written down 18. All right, so type your answer in the chat. The agent doesn't want to comply with what the seller is asking. So Ms. Lisbeth, you want back to Facebook. You must be driving. I think that's what you do. It looks much better. Okay, well, let's type the answer. Come on, come on. Or I'm going to type the answer. The answer is B. The agent has not violated any fiduciary duty. Okay, we cannot steer, we cannot limit who we're going to market to. We market to the world. Okay, so seller is saying market to only families on the west side. No, that's limiting. That's sheesh. That's discrimination. Okay, forgetting the word. Okay, moving on. All right. Thank you for pointing out. I do my best to accommodate. Number 20. An owner's agent is showing a buyer a residential property for sale. So who? An owner, a seller's agent, right, is showing a buyer a residential property for sale. The buyer notices water stains on the foundation, walls, and floor and informs the agent. Okay, so who notices it? The buyer. Okay, points it out to the agent. The appropriate course of action for the agent is to do what? A, immediately contact the paint to paint the ceiling. B, immediately contract to repair the roof. C, suggest the buyer make a lower price offer. Or D, inform the seller. Type your answer in the chat. Come on, come on. Remember, in the real world, you're limited on time to choose an answer. You know, I recommend you use less than a minute per answer, right? You have every state has a different amount of time. Texas, we're given 4 hours. However, we've got 85 national questions and 40 state questions. Okay, that's 125. So if you take 2 minutes per question, you've already got 240. So 60 minutes times 4 minutes, right? I mean, 240 minutes is actually 4 hours. And that would be 2 minutes per it. So you want to answer it hopefully in less than a minute, 50 seconds. The answer is D. Very good. Inform the seller, because they represent the seller, owner's agent. Okay. Very good. B says immediately contract the repair. Oh, heck no. Okay. Because who's going to pay for it? The seller. Seller has to make the decisions, not the buyer. Not the listing agent. Listing agent informs the seller and may make a recommendation to do so to make sure that things are taken care of. And it's up to the seller whether they want to contract a repair to a roofer to repair it. It is not our responsibility. We cannot legally hire a contractor to do it without the seller's direction and something in writing. In fact, we give 3 recommendations to our clients of who they can choose if they don't have a contractor or a service provider. And also, never do a price change or anything to a listing without a seller's signature. I heard yesterday from a seller that I plan to represent. Their property expired. So I'm cold calling and doing expireds. And the realtor they had would just call and says, hey, we need to reduce the price. Okay, reduce it. They reduce it. I said, did you sign an amendment every time? No. Oops. 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 Major, major, major oops. That was, I was about to type 3 suggestions. Yes, so it is, we recommend 3, okay? So answer was B. I mean, D as in dog. Tell the seller, because that's where the fiduciary responsibility lies. 21. The meaning and salient characteristics of the agency relationship should be disclosed to the client. Right? They're a client, not a customer, not a prospect. They're a client. There's an agency relationship, right? They signed a document. A, prior to completing a listing agreement. B, prior to or upon completion of an offer. C, upon initial contact with the person. Or D, prior to showing properties. The meaning and salient characteristics of the agency relationship should be disclosed to the client when type your answer in the chat. Think a little faster. You want to be able to practice your questions and answer them faster so that you are better prepared for the exam and finish your exam in time. mean, you have more than 1 minute per question. However, the quicker you answer them, the more of these you do, the more you practice the same things, then the better and the quicker you will get. The answer is actually A, prior to completing a listing agreement. Okay, let's see, we had C. C says upon the initial contact with the person. No, it is before completing a listing agreement. Okay, we explain the meaning and the salient characteristics of the agency relationship they're going to develop. Okay, just before signing a document. It has been disclosed earlier at a substantive conversation of a particular property, right? Specific property. So the answer is prior to completing a listing agreement. Number 22. So did you get that? Yeah, Lisbeth. Okay. Number 22, when must a listing agent disclose his or her agency relationship to prospective tenants or buyers? Some states do tenants, not in all states. We do in Texas because we have rental properties listed. So when must a listing agent disclose his or her agency relationship to prospective tenants or buyers? A, immediately prior to the initial contact. B, upon initial contact. C, whenever substantive communication is made beyond casual conversation. Or D, immediately following any offer executed by the customer. Well, they're not necessarily a client yet, okay? They are, so let's answer this question, then I'll go back. They will be a client once they've signed the listing agreement. That's the agency relationship. So number 22, it is not B. Take another attempt. No, it is not A either. The answer is C. Whenever substantive communication is made beyond casual conversation. Casual conversation, they would say, hey, you know what? We're looking for, some property, maybe in the next, few months. And so it's not substantive communication about a specific property. When they're asking for more details, they're being more general, more casual. Okay, so whenever we must disclose in detail the agency relationship is when there is a serious communication, okay, beyond casual conversation. Unless we're representing the seller and they're calling about the seller, and we need to disclose, hey, we have a relationship with our seller, they're our client. So the answer is C. Very good, Paige. So upon initial contact, no, they may just call and say, hey, could you send me this listing, or could you give me somebody else's phone number? Could you let me know where you're located? That's initial contact. It could be text, phone call, email. When they start asking about a specific property, then it's more substantial. Okay, y'all get that? It took me a while to understand substantial versus initial contact. Number 23. A buyer agent or tenant representative should disclose his or her agency relationship to the owner's agent. A, immediately prior to the initial contact. B, upon initial contact, C, immediately prior to substantive contact, or D, immediately following any offer executed by the landlord. So a buyer agent or tenant representative should disclose their agency relationship to the owner's agent when? So this is agent to agent, realtor to realtor, broker to broker. They're each representing a client, or the buyer agent has a prospect or customer. It's a little different when we are dealing from agent to agent. Although the MLS, okay, we'll disclose it, our marketing, except if it's on like Zillow or Trulia or things like that, you know, they kind of lead you on to think that whoever has it on there and the realtor that they show is the listing agent. Well, not necessarily. You look down below and then you'll see who the actual agent is, or the brokerage, or if it is a for sale by owner. So yes, the answer for 23 is B as in boy, upon initial contact. So that's between realtor to realtor, agent to agent. Okay, so it says a buyer agent must disclose the agency relationship to the seller or seller's agent on first contact. So let's say it's a for sale by owner. Then we let them know right then and there, hey, I'm a realtor with so-and-so. Substantive contact is assumed to occur immediately in this circumstance. Okay, because they're calling about a specific property. You want to make sure they're talking to the listing realtor or the buying agent. Let's see if 24. I know, I wish it always worked where it could be the perfect point, but I would almost have to change like to a smaller font, and then it's not as dark. And it still didn't work, so I like the bolder font. So it's going to be a little bit smaller, okay? Right there. 24, an agent is operating as a disclosed dual agent on a transaction. In this case, the agent, what? A, may not represent one party's interest to the detriment of the other. B, must operate without a listing agreement. C, must be obedient and loyal to both parties. Or D, must require that the principals refrain from disclosing any material facts to them. Okay, so these are in states where there is dual agency. Okay, there are, in Texas, we don't have dual agency. We only represent one client, but we can write the contract for the other, the buyer. So agent is operating as a disclosed, they're disclosing, I'm representing both sides in a transaction. So what must the realtor do in that case? Well, let me take the word must away, okay? No, we have the responsibility of confidentiality when dealing with a client. So when the client principal refrain from disclosing, any material facts, must require that principals must share material facts with us. And so the agent is A, may not represent one party's interest to the detriment of the other. Why? They're representing both parties. So when I'm representing the seller, I'm wearing the seller hat. When I'm representing the buyer, I wear the buyer hat. So we have to keep everything confidential and represent each client without sharing their information, what they're willing to accept as an offer, and what the buyer is willing to offer. We cannot share that with the other party. We have to keep a lot of things confidential about the transaction. However, material facts, okay, seller must disclose those material facts that impact the decision making of both parties. Okay, so yes, of course, you got it. So they have to represent both equally. All right. Did I type the answer? No. Okay. So let me see what it says here. So a dual agent's first duty is to disclose the agency relationship to both parties, that they represent the other party. So they're representing both. So in Texas, it would be intermediary, but that would be the broker, not the agent. So a dual agent's first duty is to disclose the agency relationship to both principal parties, or to withdraw from one side of the duality. After disclosing, the agent must obtain the written consent of both parties. If both parties accept the dual agency, the agent owes all the fiduciary duties to both parties except full disclosure. Got it? Full disclosure, not undivided loyalty, and exclusive representation of one principal's interest. And if a client does not want to have both, and the agent has a buyer rep agreement with the buyer and a listing agreement with the seller, and the buyer says no, or the seller says no, I don't want you to represent the buyer, then we must inform the buyer of that and give the option to the buyer of, refer them to another realtor or end the agency relationship with them by terminating the buyer's rep agreement. Then they would represent themselves. Okay. Why is C? Well, because what they cannot do, the agent cannot represent. Okay, we do obedient and loyal to both parties. We do have a listing agreement. Okay, we don't operate with a listing without a listing agreement or without a buyer's rep. And we're loyal to our client, but not necessarily totally obedient, right? Because what if the buyer or the seller tell us to do like in that other question? Oh, only to families on the west side. Okay, you can't do that. That's prejudice, right? And by the fair housing laws, we cannot discriminate. So we are not totally obedient to everything that they instruct us to do if it violates legal laws or laws, okay, legality. So we do have to be loyal to both. So, on here it says, after disclosing, the agent must obtain a written consent. Okay, so, B says, without a listing agreement, no, we would be representing them. So we have to have a listing agreement. And then both parties accept the dual agency. Agent owes the fiduciary duties to both except full disclosure, undivided loyalty, and exclusive representation of one's principal's interest. Okay, but not always accepting everything. So did I type the answer? Not yet. So let me type the answer. So that is the answer for A, 24A. All right, we have a comment. I'm listening, but I'm getting a haircut. Oh, I see. Well, enjoy the haircut. She passed both national and state. I listen to Lillie's videos nightly and at lunch. I manifest prior to my exam, and I am a good test taker, and I prayed, right? Believe that it's an easy exam, that you are a good test taker. Do it every day, every night, whenever you're studying. Set a schedule on your calendar, write it down, and commit to it. Consistency is what's going to help you. Study in short spurts, take a 1 to 3 minute break, and go back to studying. Excellent. Thank you so much, Esmeralda. So that's what's required, okay? If you don't end up passing and you're complaining, oh my God, I didn't pass. So how much did you study? Did you have a regular schedule? Did you focus on creating a positive mindset? Okay, did you do affirmations? And, did you focus on that you passed, you've got it, and you took an easy test, all right? And you remember everything. Must do that. And you're a good test taker. You have 50-50 chance, right? So why not choose the positive versus the, oh my God, what if I don't pass? Oh my God, I'm not going to pass. Oh my God, I can't do this. Oh my gosh, I don't know this. Say, yes, I know this. I'm passing. I'm excellent test taker. I remember like an elephant. Okay, I do this. I passed. That's what you got to do. All right, number 25. An agent informs a buyer that a provision in a contract is very commonplace. After explaining the clause, the agent assures the buyer that the clause does not mean anything significant. If something goes wrong with the transaction, the agent could be liable for what? So what are they saying? Agent informs a buyer that a provision in contract is very commonplace. A provision in the contract. Okay, remember, what can we or can we not do? How are we licensed? So the agent could be liable for A, violating duties owed a customer, B, in misinterpreting the clause, C, intentional misrepresentation, or D, practicing law without a license. Type your answer in the chat. Paige, you wrote 25, but which answer? Oh, typo. Yeah, I do that too. Type it up, type it up. All right, the answer here is D, practicing law without a license, right? Because what are they doing? A provision, okay, a clause or something in the contract is very commonplace. No, they are legal templates. That is not our place because we are not attorneys. If the client or the individual principal, seller, buyer has questions on that, then go to an attorney. All right, so that is the last question for national. Any questions on the national part? Type your question in the chat, and we're going to move on to Texas state questions. So we just did 15 national. And if 15 is not enough for you on this video, there are other YouTubers, okay, that have been realtors, brokers, agents that also tutor, and they go much faster because they don't elaborate on the question and on the answers. They just read the question, the answer, the question, give you the letter answer, and then read the answer, and then go to the next one. So there are individuals that can accommodate different individuals to go faster through the questions. So I'm thinking of doing that too. And then when I did that, it's like, oh, could you slow down? Could you explain? So now what I'm doing is creating shorts of prior videos, like to do one question at a time, one thing at a time in a 1 minute. So that those who want to watch it really quick and short, then it'll accommodate that. Can't please everyone 100%, right? So can't, we got to let go of the naysayers or complainers. We have a choice. So anybody that's here right now and you're watching on YouTube, hey, send me some love. I only have 2 thumbs up. So you know what to do, right? Tap the subscribe button if you're not following me, or subscribe to my YouTube Agent Prep channel. Click that little bell so that you're the first to get notified every time I go live or I upload a video. And tap the thumbs up and send me some love and support for doing this. No questions? Then we are starting with the Texas state questions. And I wish I could do, all the other states. It's like, woo, I have to buy other books. I have to make more time. So it's a lot more work. Or I have to not accommodate the Texas, which, I don't accommodate other states, right? When I do just Texas. So I'd have to buy the books and review the material, understand it for the state portion. All right, number 16. Oh, I should have showed you what these questions were concerning. So these are special topics, okay, down here in the Texas real estate, test number 16. All right, so anybody who's here from National, you're welcome to stay and continue learning on how I break down sometimes the question or the answers if they come across rather difficult. All right, number 16, constructive eviction. What is constructive eviction? There's different types of evictions, right? Is best described as which of the following? A tenant self-eviction, where the tenant with notice abandons the apartment due to landlord's failure to maintain habitability. What is habitability? Abandon. Self-eviction. B, a tenant abandons the apartment and the landlord makes the vacancy official by filing a constructive eviction notice. C, a tenant is in a dispute with the landlord, withholds rent until his or her deposit is returned. Or D, a landlord forcibly evicts a defaulting tenant in lieu of a writ of possession. So type your answer in the chat, including the question number and the letter answer. Come on, type the answer. I'm going to go a little bit faster. So yes, the answer is 16A. A tenant self-eviction, where the tenant with notice abandons the apartment due to the landlord's failure to maintain habitability. Constructive eviction, you're giving someone a notice, okay? You're handing it to them, emailing it to them, texting, whichever way is permitted according to the lease agreement. So the tenant evicted themselves because the landlord is not providing a livable environment. okay, a habitable property. So very good. Number 17. And every state has landlord-tenant laws. Non-judicial foreclosures, like most legal proceedings, require that proper notice procedures be followed. In the proceeding, the notice of sale must precede the sale date by A, 7 days, B, 14, C, 20, or D, 21 days. So this is a foreclosure proceeding in the state of Texas. After how many days can the deed of then the trustee start the foreclosure process? Start sending out notifications. We are a non-judicial foreclosure state because our mortgages are called deed of trust. No, it is not 7 days, VB. Victory baby or Victor boy, or the answer is D. 21 days in Texas, okay, and a non-judicial foreclosure, like most legal proceedings, require proper notice procedures be followed. In this proceeding, the notice of sale must precede the sale date by 21 days. Okay, the notice of sale. So they already sent them a notice giving them an opportunity to cure it, you know, and if they don't, they say, hey, after 21 days, we are starting a foreclosure process, and which is legal per the state of Texas. Now, do they all start within 21 days? No, it depends on the lender. Other states have 4 months, 5 months. When I was in Oregon, we had 4 months. 4 or 5 months. Trying to remember. Okay, number 18. Oh, come on. Dang it. Gonna be smaller. Dang. That can't be. There's got to be an in between here. It's not going to happen. Come on, D, show up. There. Okay, number 18. In non-judicial foreclosure, which Texas is, the foreclosure price may be less than the loan balance, or it may be less than market value. With that as a given, which of the following is true? When the loan balance is greater than what the property can sell for. A, if the foreclosure price is less than the market value, the lender may pocket the difference. B, if the foreclosure price is less than market value, the debtor is entitled to an offset equal to that margin. Or C, if the foreclosure price is less than the loan balance, the creditors must absorb the difference on their books. Or D, if the foreclosure price is less than the loan balance, the creditors have 3 years to recover the difference from the debtor. So in other words, they like now we had forbearances where individuals, were given the opportunity of not making their payments during COVID. Okay, so then now if they don't come up current with their payment, or the loan was added at the end, the forbearance, they may be foreclosed on, but it doesn't mean that the property value depreciated, went down on it lower than what they owe. So in this case, it's like they're saying, if the loan balance is less than the market value, what is a given? All right, we have B so far. B. And yes, the answer is B. If the foreclosure price is less than the market value, the debtor, okay, the borrower, is entitled to an offset equal to that margin. So the foreclosure might have been for 200,000 and the property value was, 300,000 and it brought in 350. Then the borrower is going to get the difference from the lender after all attorney fees and all other fees for the foreclosure were recovered by the lender. When there isn't enough money brought in from the sale and they don't pay off, they're not able to pay off the loan, then that is a short sale. The market went down far enough that it went below the loan balance. That is a short sale. Okay, number 19. In a judicial foreclosure, okay, pay attention, doesn't say non-judicial. Now it says judicial foreclosure. The court issues a judgment to sell the collateral property. What kind of property? Collateral. What is collateral? Look it up. Following the sale, the debtor has a window of time to determine if there is an excess of market value over and above the sale price. If so, the debtor may obtain an offset for the difference. This window of time is what? A, 90 days, B, 180 days, C, 1 year, or D, 2 years. Type the answer in the chat. Come on, come on, come on. Do it, do it, do it. Yes, the answer is A, 90 days. So if the debtor, who's the debtor? The borrower, right? It was the buyer. It's the owner, may obtain an offset for the difference. So if it's sold for more than what was owed, then they'll get the difference, and it is within 90 days. If the court issues a judgment to sell the collateral property, following the sale, the debtor has a window of time. In other words, they're saying, oh, the lender is not voluntarily sending them the money, and if they don't get it, they have a statute of limitation, right, of 90 days. Number 20. Oh, here comes what I just talked about, right? Short sale doesn't mean the sale is short and quick. 20. In a short sale, the sale price is less than the mortgage amount. Which of the following is a critical issue for the seller in completing a short sale? A, obtaining an appraised value that exceeds the mortgage amount owed. B, getting the buyers to agree to make up for any deficiency. C, getting the lender to provide a full release of the lien at closing. Or D, reporting the correct amount of debt forgiveness to the IRS. All right, but we've got C so far as an answer. Anyone else? No one else? The answer is C, getting the lender to provide a full release of the lien at closing. And why is that? Because if that buyer decides to then sell the property, if they go to buy another property and they don't have a release of liens on that, it's going to show as a cloud on their title report or on their credit bureau that they have a loan still owed. So that lien release must be provided by the lender. And if they don't voluntarily provide it, it's the buyer's right or the owner's right to get that release of liens and have it recorded so that debt doesn't show up on their record. Now, it's going to impact their credit score because they defaulted on their loan and it's being sold and there was a deficiency. And then it's the lender's discretion whether to have a deficiency judgment on that borrower. Deficiency judgment means, hey, you still owe us money. We're going to give you these many years to pay it. Number 21. Let me see if I can make it even larger. No. According to Texas Property Code, recording real property conveyances has which of the following legal effects? Recording real property, right? That's what we record. Conveyances. What is conveyances, right? It's transferred. It's abandoned by the owner and received by the borrower, right? Has which of the following legal effects? A, it finalizes the conveying process. Recording triggers passage of title. B, it causes the transaction to be legally binding on the principal. C, it prevents a transaction from being void with respect to creditors and subsequent buyers. Or D, it enables the buyer to remove all liens on the property. Oh, I forgot to enter number 20. All right, so we've got C. So we're doing 21, and all of a sudden 20 showed up because I hadn't posted it on Facebook. So going once, going twice. Answer, type it in the chat. Gone. The answer is C. It prevents a transaction from being void with respect to creditors and subsequent buyers. So once it gets recorded, like I mentioned, right, and they get the release of liens, and so recording real property conveyances, once a property is sold, it is recorded by the title company, and it is the borrower's, the new owner's responsibility to go and make sure that it was delivered and recorded and it's in their name, because mistakes do happen. Because if not, if somebody ends up recording a ownership of that property, now the real owner has an issue. It's been recorded to the public. Everyone knows that it belongs to John Doe instead of to Mary Jane Doe. Okay. So sometimes individuals lose properties like that for being careless and not making sure that things are recorded, or making sure that the title company, the escrow officer, or the attorney who could be the escrow officer, right? They do closings also of conveyance of property. Conveyance, a purchase and sale transaction, a seller conveys the deed, okay, and title ownership to the borrower, to the new owner. Oh, now it shows much bigger. All right, number 22. An essential distinction between actionable fraud and intentional misrepresentation is that, so what's the difference between the two? Essential distinction. Actionable or intentional misrepresentation. So A, fraud requires two or more parties to commit the law violation. B, misrepresentation implies that the misrepresenting party did not realize the statement was untrue. C, misrepresentation requires that the client relied upon the misstatement made. Or D, actionable fraud must have resulted in damage to the defrauded party. So difference between misrepresentation that was intended to misrepresent a client or a customer or a prospect, or fraud that actually happened, right? Type your answer in the chat. Going once, twice, gone. The answer is D. Actionable fraud must have resulted in damage to the defrauded person or party. That's the difference between actionable fraud and intentional misrepresentation. You know, intentional misrepresentation is what, when we say something incorrect about something that in property and real estate. Okay, so, and we're doing it with the intent to hurt the other party. We don't want them to know the real truth. However, it didn't cause any financial damage or other type of damage. Okay, any questions on Texas State? We're calling it a day for Texas State questions, or let me see how many are left. No, there's enough for next session. Any questions? This is the time to ask. So soon you're going to take your exam and you're going to be a realtor. You're very welcome, Lisbeth. And realize that if for some reason you don't pass the exam, it wasn't that, oh, God didn't mean you to pass. It wasn't meant for you. Hey, you've got to work hard at it, okay? It takes a lot of work to get a degree from college and high school and junior high. And there's exams that we must take in order to make it to the next level. So this is a transition to another level that you want to go to in your life or career or have your own business. This is having your own business. So to have a business takes a lot of work, okay? It could be easy. It's difficult. It's a challenge. It's a lot of hard work. You've got to work your ass off. You got to study your ass off. Oops. And so, you know, it's only, you know, if for some reason you don't pass, it's nobody else's fault. Do not point fingers except for right to ourselves. We have to do what it takes, have a schedule, have a commitment, get our mind, focus on it, be in a quiet place, okay? Have earphones and listen to, you know, classical music or pleasant music that calms you down. Do things to calm yourself down. Meditate prior, you know, let your family know to give you support, that you're going to be studying and you need their help to be quiet. Or to you go to another room, go to a public place like a library. Take yourself out of the house, out of that environment that triggers you to keep wanting to go to the refrigerator or do other things, or, you know, check out your phone, alerts or whatever, calls, put them away. If you're doing it on the phone, okay, mute, okay, the alerts. Okay, put it on do not disturb, so that you don't even hear vibrates. Because every time something interrupts you, it takes minutes to get our focus back on. It's up to you to pass this exam. It's up to you to prepare for this exam and do what it takes, should you really want it. Now, some unfortunate news is that a large percentage of realtors, students that become realtors, drop out of the business because they're not understanding or doing enough research or realizing what it really takes once the business of real estate begins. You're very welcome, Paige. You're very welcome, Lisbeth. So it's a lot of work, and we're always growing and learning. The learning isn't going to stop. The reading and, you know, taking other tests, except you're not quite graded. We have to renew our license every 2 years in Texas. And you've got to constantly keep learning, reading books, networking with other individuals, and take action. Go and do it yourself. Don't expect somebody else to push you or to do it for you. You've got to do it yourself. You've got to be a self-motivator. There's no boss telling you, hey, you got to do this by this deadline. No, you're the boss of you. I'm the boss of me. This is my business. This is your business. So do what it takes and do it now. All right. Thank you all for attending. Remember, I am an active realtor doing real estate, and I'm now doing cold calling. Plus, I'm doing videos on my Living in San Antonio, Texas channel to attract buyers. And on the cold calling is to get listings to represent sellers. So yesterday I got one. Woohoo! Not signed yet. Okay. But I met with the client on Zoom. And when you're ready to start interviewing companies, sponsors, hey, interview several of them. Get a feel of what works for you. Do you need to go to an office, a brick and mortar office? Then go interview brokers that have a brick and mortar office. If you're okay with working out of your home, you're a self-learner, self-motivator, and you can push yourself. All right. Then you might be interested in a company like EXP, which we are a virtual company. And we network with people throughout the world on our EXP world in the cloud, right? We are leading technology and we provide a lot of training and education. However, we're not for everyone. All right. And if you've heard negative things about EXP, you're going to hear negative things about all different brokerages. Okay. Don't listen to the naysayers. Find out for yourself. All right, y'all. Thanks again. Until next time, this is Wild Lily Handy coming to you from San Antonio, Texas with whom? YouTube AgentPrep. See you all Monday. Thank you, Reswitty. Send me some love. Click that thumbs up.